The wind howled outside the Royal Courts of Justice in London that morning. An eerie stillness settled over the crowd that had gathered near the steps. Reporters clutched their microphones tightly as the first words trickled out from inside. Prince Harry, once the crown's beloved rebel, was now standing in the eye of a storm. The battle he had waged for nearly 3 years to regain his royal police protection had finally come to an end. And the verdict wasn't in his favor. But that wasn't the worst of it. What began as a routine civil case quietly escalated into something far more sinister. As Harry's legal team pushed hard to convince the judge of the grave threats against his life, allegedly due to his royal bloodline and media visibility, a deeper, more disturbing narrative emerged. Accusations of hidden documents, tampered emails, an internal warning sent directly to Buckingham Palace that mysteriously vanished. And now, the UK's Crown Prosecution Service was formally considering charges against the Duke of Sussex for obstruction of justice and withholding critical evidence. It was a moment few could have imagined. Not long ago, he stood tall on international stages, celebrated for his candor, his service, and for breaking away from the tight grip of royal traditions. Today, that same independence had landed him in the defendant's chair, trembling as the judge read aloud the final ruling. Across the Atlantic, the royal family remained conspicuously silent, their lawyers watching the proceedings with detached precision. No public statements, no messages of support, only cold eyes from the gallery and the slow, measured scribble of court reporters capturing every painful word. A far cry from the royal weddings and grand tours. This was something else. This was humiliation. To understand how Harry got here, you have to rewind. Go back not just to the day he and Meghan stepped away from their royal duties, but even further, to the days when protection was automatic, when threats against his life were handled discreetly by elite Scotland Yard units, and when the British press still regarded him with a mix of reverence and curiosity. When Harry left his senior royal position in 2020, the expectation was that his security arrangements would shift. But no one anticipated the complete removal of his taxpayer-funded UK police protection, particularly given the known threats that had shadowed his life since childhood. To him, the decision wasn't just bureaucratic, it was personal. A punishment. A warning. One that could potentially put his life and the lives of his wife and children at risk whenever they returned to British soil. So he sued. The lawsuit was intended to be straightforward, restore his security privileges based on documented threats. But from the outset, something didn't sit right. The Home Office claimed that Harry was aware of the process, that he had accepted the terms, that he had received proper notice about his protection being stripped and the reasons behind it. Harry's lawyers, however, countered with a different version, that there had been a failure of process, a denial of his legal rights, and a dangerous politicization of his safety. The courtroom became the new battlefield. Behind closed doors, away from media cameras, the testimonies were sealed, the documents marked classified. But leaks happened. Whispers from within the royal circle suggested that there was more at stake than simply a security detail. Rumors swirled that Harry's legal team had failed to disclose emails that contradicted his sworn statements. That during the discovery phase, several files were quietly redacted, files that should have been reviewed by the court. And worse still, that the Home Office had flagged this omission and referred it to criminal investigators. Suddenly, what had begun as a civil complaint was morphing into a criminal investigation. And Harry? He went cold. Onlookers described his demeanor during the final days of the trial as distant. He no longer smiled walking in or out of the courtroom. His once fiery confidence had turned into a tightly controlled stoicism. No Meghan by his side. No high-profile royal supporters. Only his legal counsel and a few trusted aides who looked just as rattled as he did. The judge's ruling came in 2 parts. The first was expected. His appeal to reinstate police protection at the taxpayer's expense was denied. But the second part hit like a punch to the gut. The court issued a scathing rebuke of Harry's handling of the case, accusing his team of a reckless disregard for evidentiary integrity and citing credible indications of deliberate omissions. Those words echoed across news outlets within minutes. And then, the headline broke. Prince Harry faces possible criminal charges over withheld evidence. The BBC cut into programming. Sky News scrambled to gather statements. Social media erupted with speculation, anger, mockery, and disbelief. Royal watchers were stunned. But not everyone was shocked. Some had warned this would happen. That you can't challenge institutions as old and ruthless as the monarchy and the British justice system without consequences. That Harry had miscalculated. Badly. Behind the scenes, the Crown Prosecution Service initiated what it described as a preliminary review of prosecutable offenses related to Harry's evidence submissions. According to insiders close to the investigation, 3 digital correspondences and 2 hard-copy documents were never submitted during discovery. What's more damning is that they were allegedly withheld after direct requests from the opposing counsel. If proven true, this wouldn't just be a case of clerical error, it would amount to obstruction, punishable under UK law. And so, the prince who once wore military regalia with honor may now face the cold interior of a courtroom not as a plaintiff, but as a criminal defendant. This fall from grace isn't just about legal technicalities or courtroom etiquette. It's about betrayal, at least from Harry's perspective. Betrayal from the monarchy, from the system he was born into, and maybe even from those he thought were on his side. Because as the court's opinion made clear, someone inside his camp had made critical decisions regarding what was submitted and what wasn't. The silence from the royal family became even louder. No statements from King Charles. No word from Prince William. Just the tight-lipped protocol of the institution protecting its legacy, letting one of its own take the fall in silence. And if there was anyone still unsure whether Harry was truly on the outside looking in, this moment left no doubt. But what happens next? Will prosecutors formally charge him? Will Harry return to court again? This time not to defend his rights, but to defend his freedom? The story is no longer about protection. It's about exposure. And Harry, for all his charm and defiance, may finally be realizing that he's up against a machine much larger than he ever imagined. The battle began with a letter. Not from the palace, not from a tabloid, but from a solicitor's desk deep within London's legal district. The letter was official, assertive, and, as Prince Harry would later claim, necessary. It was the first formal move in a legal war to restore what he believed had been unjustly stripped from him, the right to be protected on British soil. To the public, it seemed like a routine lawsuit, another celebrity demanding privileges. But to Harry, it was personal, very personal. When he and Meghan Markle announced in early 2020 that they were stepping back from their royal roles, few could predict the full consequences of that decision. The couple had endured intense media scrutiny, much of it scathing, some of it overtly racial. They had faced an overwhelming tidal wave of public pressure, palace resistance, and media harassment. Seeking peace, they relocated to North America, first Canada, then Montecito, California. But what didn't follow them was the full scope of British police protection they once enjoyed. For any royal figure, the question of security is not just about prestige, it's about survival. The death of Princess Diana in a high-speed chase through a Paris tunnel still casts a long shadow over the royal family. For Harry, who was just 12 years old at the time, the trauma of losing his mother to the consequences of paparazzi pursuit was more than a media talking point. It was a lifelong scar. So when the UK government revoked his automatic police protection, citing his new status as a non-working royal, Harry took it as a death sentence. According to documents later revealed in court, Harry's legal team argued that the prince continued to face credible threats, even after stepping back from royal duties. They cited extremist chatter, credible plots flagged by MI5, and online death threats that surged following the couple's televised interview with Oprah Winfrey. Harry's lawyers claimed that the absence of protection would deter him from visiting his homeland, effectively exiling him from the country of his birth. In one especially emotional moment during the trial, Harry's legal representative recited a line from an email the prince had written to a senior aide at Buckingham Palace. "How can I keep my family safe if the institution has made me vulnerable?" The words, reportedly written just days after his security was revoked, were powerful, but they weren't enough. The Home Office, acting on behalf of the British government, responded with cold logic. Harry, they argued, had made a voluntary choice to step away from his duties. He could not cherry-pick the benefits of royalty without fulfilling the obligations. Furthermore, they insisted, police resources were finite and needed to be allocated based on risk, not status. The argument carried weight. After all, there were dozens of public figures who faced threats and relied on private security rather than state-funded protection. But Harry pushed back harder. In 2021, he initiated judicial review proceedings against the Executive Committee for the Protection of Royalty and Public Figures, also known as RAVEC. This committee, composed of senior officials from the Metropolitan Police, the Cabinet Office, and the Royal Household, had been responsible for evaluating the risks and determining the level of protection necessary for royal individuals. Harry alleged that Ravek's decision-making process had been biased, opaque, and procedurally unfair. He argued that they had denied him the opportunity to make his case properly and that they had not adequately considered the threats against him. Ravek, in its defense, countered that Harry had been given the chance to participate and had chosen to pursue legal channels instead of informal resolution. They maintained that he no longer qualified for publicly funded protection and that their decision was consistent with precedent. But behind the scenes, there was clear tension. Some insiders speculated that Harry's very public break from the family and his repeated criticism of royal protocols had soured the committee's opinion of him. He was no longer seen as an asset but as a liability. Harry's legal battle gained traction in international media. Commentators debated whether he had a legitimate case or was simply clinging to royal privilege. Supporters rallied around him, pointing out the rising tide of threats and the unique risk he posed as a target for extremists. Detractors argued that Harry and Meghan had chosen to monetize their identities through lucrative media deals, and it would be inappropriate for UK taxpayers to fund their security while they lived abroad in luxury. In early 2022, the case took a dramatic turn. Harry offered to pay personally for police protection while in the UK, a move designed to dismantle the argument that this was about money. But the Home Office stood firm. Police officers, they argued, were not for hire. Their deployment was not a matter of private funding but of public responsibility. Allowing individuals to pay for police services, especially for private benefit, would set a dangerous precedent. The offer was rejected. That rejection fueled Harry's resolve. His team intensified their legal efforts, filing affidavits, collecting threat assessments, and making their case that the Duke of Sussex had been unfairly treated. They argued that high-profile visits such as those to attend the Queen's Jubilee or to honor his mother's legacy at charity events placed him directly in harm's way. These weren't vacations, they were public duties, even if informal. The case unfolded slowly, tangled in bureaucracy and procedural challenges. And as it dragged on, a troubling pattern began to emerge: discrepancies in the documents submitted by Harry's team. Redacted communications, missing schedules, emails that appeared to reference meetings which were never mentioned in court filings. The Home Office flagged these inconsistencies, and although they didn't halt the civil case immediately, they laid the groundwork for something far more damaging. By the time the hearing reached its final stage in 2024, the mood in the courtroom had shifted. What began as a case about safety had become a referendum on honesty, privilege, and responsibility. The judge presiding over the case made several pointed remarks about the necessity of transparency, especially when dealing with national security concerns. The burden of proof, he reminded both parties, fell heavily on those asking for special accommodations. And in the end, Harry fell short. The court ruled that the Home Office had acted within its rights and that the decision to strip the Prince of police protection was legally sound. But buried within the final ruling was a paragraph that changed everything. The judge cited alarming concerns regarding the completeness of the evidence submitted by Harry's legal team and referred the matter to the appropriate investigative authorities. That referral set off a firestorm. For the first time, the word criminal entered the conversation. Insiders revealed that the Crown Prosecution Service had quietly opened an inquiry into potential obstruction of justice. The question was no longer whether Harry deserved protection, it was whether he had lied to get it. Or, more precisely, whether someone under his direction had tampered with or hidden documents that could have altered the outcome of the case. The backlash was immediate. Tabloids plastered the headlines with dramatic flair. From palace to prison, screamed one cover. Another featured a split image of Harry in military uniform and in a courtroom sketch, with the caption, "The Prince and the Paper Trail." For Harry, the ruling was a devastating blow, not just to his case, but to his credibility. And the implications were still rippling outwards, toward Meghan, toward their children, toward every future visit they might make to the UK. More importantly, toward the institution he had once called the firm, and which now seemed perfectly content to let him twist in the wind. At the heart of it all was the one question that the court couldn't answer: why had these documents been withheld? And that question still hung heavily in the air as the courtroom emptied, leaving behind silence, shock, and the weight of an investigation still to come. The marble floors of the royal courts of justice had seen history unfold time and time again, but nothing quite like this. It wasn't every day that a royal prince, stripped of titles and family protection, stood before a judge, his voice not elevated in triumph or celebration, but quivering in frustration. As the wooden doors shut behind Prince Harry on the final day of the court hearing, all the pomp of the monarchy seemed to vanish. There were no guards in red uniforms, no waving flags, no applauding crowds. Only the tense silence of a legal showdown that had spiraled far beyond what anyone had expected. Inside courtroom 3, the atmosphere was cold, heavy, and unrelenting. Even the walls seemed to absorb the anxiety pulsing through the air. Prince Harry sat at the front bench, flanked by his legal team, eyes fixed on the stack of documents in front of him. He had been in this courtroom many times over the past year. Yet this time, something had changed. There was no quiet confidence, no subtle smirk. He looked cornered. The judge, a tall man with silver hair and an unwavering gaze, entered briskly and took his place. The final statements were about to be delivered. Tension crackled between the rows of observers. The media had not been granted full access, but that hadn't stopped speculation from flooding every corner of social media. This day would either vindicate Harry or lay the foundation for an entirely new chapter of disgrace. The proceedings began with the closing remarks from Harry's legal counsel, a seasoned barrister known for her precision and skill under pressure. She reiterated that the prince had been subject to an unfair security ruling, that the risks to his life and the lives of his family were real and immediate. She reminded the court that Harry had repeatedly offered to pay for his own protection, and that the denial of that request effectively made it impossible for him to safely return to the United Kingdom. Her words were smooth and controlled, but they seemed to glide past the judge without impact. He had heard these arguments before. What mattered now was the integrity of the process, and it was becoming increasingly clear that the court no longer believed Harry had operated in full transparency. Then came the government's representative, a no-nonsense legal advisor from the Home Office who had gained a reputation for being brutal in court but nearly invisible outside it. She didn't waste time on formalities. "There is a reason this courtroom demands truth," she began, her voice echoing through the still chamber. "Because truth is the only thing that separates justice from manipulation. This court was not given the full truth." She paused, turning toward Harry's team. "We requested 5 documents directly related to security arrangements made with the Metropolitan Police. Those requests were met with either silence or redactions so severe they rendered the contents meaningless. These are not minor omissions. These are deliberate exclusions of material evidence." Harry shifted uncomfortably in his seat. His hands, once clasped on the table, retreated into his lap. His eyes darted down, avoiding the cold stare of the judge now fixed on him. The government's lawyer continued, presenting a timeline of communication between the Home Office and Harry's legal team. She highlighted the missing emails, specifically one from a senior aide in the Duke's circle that allegedly contained key acknowledgments about the limitations of royal protection. That email, if presented in full, would have undermined Harry's argument that he had been blindsided by the Ravec decision. And that wasn't the only inconsistency. The court had been told that Harry had no prior knowledge of Ravec's ruling until after it was enforced. But new testimony from a whistleblower within the royal security detail suggested otherwise. According to this source, Harry had been briefed weeks in advance by a royal liaison. Yet the court documents implied he had received no warning at all. The contradiction struck at the core of the case's credibility. After a tense recess, the judge returned with his ruling. The silence in the courtroom was suffocating. Even the scribes at the back of the room slowed their pens. Prince Harry sat motionless, jaw clenched, a single bead of sweat running down his temple. The judge's voice was calm but unmistakably stern. "This court finds that the plaintiff's legal submissions, while based in legitimate concern, failed to meet the evidentiary standards required for a reversal of the Ravec decision. Furthermore, this court must address the disturbing indication that material evidence was either redacted or omitted entirely during the course of these proceedings." There was a pause, a long one. In light of the information presented by the defendant, the court hereby refers this case for further examination by the Crown Prosecution Service to determine whether any criminal liability exists regarding the concealment of material documents. Gasps echoed through the chamber. Even the stone-faced court officers blinked in surprise. Harry didn't react immediately. It was as if his mind had left the room. When he finally moved, it was only to press his palms into his thighs, attempting to ground himself in the moment. His attorney leaned in close, whispering, but he didn't respond. Outside, reporters were already broadcasting the development. In the hours that followed, the court was flooded with media requests, desperate for a copy of the ruling. International outlets scrambled to push the story live. The BBC, Sky News, CNN, and even major U.S. tabloids covered the courtroom drama with real-time headlines. But while the world speculated, inside the courthouse, the mood grew darker. Representatives from the Crown Prosecution Service arrived less than an hour after the court adjourned. Not to arrest, but to quietly review and collect transcripts, documents, and a sealed envelope handed over by the judge. An envelope believed to contain internal communication logs from Harry's legal team. That's when things got even worse. The existence of a private server used by Harry's former royal aides became public knowledge. According to anonymous sources, communications had been moved there deliberately to avoid visibility during the discovery phase. It wasn't illegal in itself, but it raised serious questions about motive. Why would a legal team, especially one representing a former royal, opt to store crucial information outside the main correspondence thread? In an emergency press release that night, a spokesperson for Prince Harry claimed that any omissions were unintentional and blamed the issue on a miscommunication between his UK and US legal teams. The statement attempted to strike a conciliatory tone. His Royal Highness has the utmost respect for the court and would never knowingly withhold information. But the damage had already been done. Legal experts flooded talk shows with warnings. If the CPS pursued formal charges and found that the redactions were indeed deliberate, Prince Harry could face more than just a fine. In the UK, obstructing justice is a serious offense, especially when linked to national security issues. For Harry, the emotional toll was becoming impossible to hide. Paparazzi footage captured him leaving the court with his collar raised, eyes down, refusing to speak. His security team, privately funded, formed a human shield around him. It was a far cry from the carefree man who once laughed with crowds and cracked jokes with the press. This Harry looked hardened, hunted. But it wasn't just his legal troubles that weighed on him. Inside sources revealed a growing divide between Harry and several of his closest confidants. Advisors who had once cheered him on were now questioning decisions. Some believed the lawsuit had been pushed too far, that Harry had underestimated the willingness of the British state to push back, that he had, in his desperation to feel safe, walked directly into a trap. The whispers from inside the palace grew louder too. Though no official statement came from Buckingham Palace or Kensington, reporters close to the royal beat noted a shift in tone. Royal aides were no longer avoiding the press. In fact, some were feeding it. Leaked comments from a senior figure at the palace suggested that Harry's actions had brought disgrace not only upon himself but upon the dignity of the crown. By week's end, the fallout extended beyond legal implications. Sponsors, donors, and even charitable partners began to distance themselves. The Invictus Games Foundation released a carefully worded statement reaffirming its commitment to integrity and service. The meaning wasn't lost on anyone. In a single courtroom session, the narrative had turned. No longer was Harry the wronged prince fighting for justice. He was now the man whose truth had been questioned, whose loyalty was ambiguous, whose story, once gripping and sympathetic, was being rewritten in the language of legal scandal. And perhaps most troubling of all, he had no one to share the burden with. Meghan Markle remained in California, her absence from the courtroom both conspicuous and calculated. Whether it was a sign of disagreement, caution, or disinterest was unclear. But for Harry, who once stood shoulder to shoulder with his wife against the might of the monarchy, the empty seat beside him was its own kind of verdict. The courtroom drama had played out, but the true consequences were still unfolding. And what lay ahead would not be scripted, sanitized, or softened by palace press releases. It would be raw, and it would be real. The initial courtroom decision had barely settled when an even darker shadow emerged over the case. Just as Prince Harry's legal loss reverberated through news outlets across the globe, the implications of something far more dangerous began to surface. It was no longer just about a prince losing the right to be protected by state-funded officers. Now, the discussion had shifted to something criminal, something deliberate, something that hinted at a cover-up. At the heart of this growing controversy lay a single accusation that Prince Harry, or members of his legal and advisory team, had intentionally withheld key evidence from the court in an attempt to manipulate the case in his favor. The term obstruction of justice quickly replaced royal protection in headlines. For the first time, the British public found itself grappling with the possibility that a former senior royal figure might face legal consequences not for his choices after stepping down from duties, but for the way he attempted to navigate the British legal system. The accusation did not come from a tabloid. It came directly from the judge's ruling and was supported by internal communications reviewed by the Crown Prosecution Service. When a judge states there is enough concern to warrant a criminal referral, it is not a casual suggestion. It is a serious and calculated move. Investigators zeroed in on 5 key pieces of communication that had either been excluded from discovery or heavily redacted beyond recognition. Among these was a back-and-forth email exchange between Harry's legal representatives and a senior member of his former royal security detail. The emails, timestamped nearly 4 weeks before Harry claimed to have received notification of the changes to his protection, indicated that discussions had, in fact, already taken place. The implication was clear. Harry may have known far more than he let on when he said he was blindsided by the decision. But that wasn't all. Investigators found that a document outlining potential alternatives to police protection, including private firms with MI5 clearance, had been drafted by Harry's US-based advisors and reviewed by his UK team. This document was never submitted to the court. Its omission was glaring because it directly contradicted the claim that Harry had no viable security alternatives. If he had other options, it would undercut the legal argument that his safety was completely compromised by the Home Office decision. Then came the most damning piece of the puzzle, a voice memo. Sources close to the investigation reported that a senior assistant to Prince Harry had recorded a memo after a strategy meeting in which the risks of including certain communications in the court case were discussed. The memo, which was never meant for public release, reportedly stated, "If we submit that, it weakens our position. It implies Harry accepted the terms. Better if that never comes up." The existence of this voice recording sent shockwaves through the legal team. Questions were immediately raised. Who made the recording? How was it leaked? Was it handed over voluntarily by someone within the team, or discovered through subpoena? And most importantly, who was present in that meeting? At the core of the growing crisis was a central figure in Harry's legal team, his lead solicitor, a respected professional with decades of courtroom experience. She denied any knowledge of withheld evidence and claimed that all document redactions were done to protect national security and the privacy of royal correspondences. Her statement was delivered with calm professionalism, but it did little to quell the fury now boiling beneath the surface of public opinion. Meanwhile, the CPS investigators quietly began compiling files, issuing notices to individuals connected to the case. Digital devices were requested. Server access logs were examined. Communication between Harry's US-based legal team and UK representatives was dissected. It became increasingly clear that what had initially seemed like an overly aggressive lawsuit may have, in fact, been built on shaky ethical ground. And through all this, Prince Harry remained silent. His team issued a single brief statement through a spokesperson. The Duke of Sussex has no knowledge of any intentional concealment of evidence and maintains full confidence in the integrity of his legal team. But for critics and skeptics, this statement only raised more questions. If he didn't know, should he have? And if he did, what did that say about the man who once vowed to bring transparency to every institution he touched? Within days, political commentators and legal analysts began to weigh in. Some saw the emerging scandal as the inevitable backlash of a prince who had tried to play a system he no longer understood. Others, particularly in the United States, viewed it as part of a broader campaign to discredit Harry for breaking away from the crown. Was this a vendetta from within the monarchy, executed through legal means? Or was it a case of self-inflicted wounds brought on by pride, overconfidence, and entitlement? The public reaction was split. Some maintained that Harry was still the victim of systemic bias and that any mistakes made by his team should not overshadow the very real dangers he faced. Others were less forgiving, interpreting the revelations as proof that Harry had grown too accustomed to bending the rules in his favor. Online forums exploded with speculation. Was Meghan Markle involved? Was she part of the strategic meetings where decisions about document submissions were made? If so, why hadn't she publicly defended her husband during this ordeal? Her absence from the courtroom, once interpreted as a move to keep the focus on Harry, was now being read differently, more skeptically. Royal biographers and insiders began publishing unofficial accounts, claiming that private conversations within the palace described Harry as completely adrift, and that the Queen herself, before her passing, had warned close aides about misguided lawsuits. The leaks were unverified, but they fueled the fire. To make matters worse, a former royal aide who had resigned shortly after Harry left the UK surfaced in a televised interview. Speaking anonymously, with voice distorted and silhouette darkened, the aide claimed that Harry's inner circle had developed a habit of selectively sharing information, not just with the press, but within the legal and political systems they encountered. His advisors believed they were smarter than the process, the aide said, that they could outplay the system. But the system doesn't forget. And it certainly doesn't forgive. As the CPS ramped up its inquiry, legal documents began to surface indicating the scope of their investigation had expanded. They weren't just looking at this case anymore. They were reviewing Harry's past legal filings, comparing statements made under oath in different jurisdictions. A pattern, they suggested, was beginning to emerge, a pattern of exaggerated claims, selective evidence presentation, and strategic omissions. For Harry, the implications were terrifying. In legal terms, even if he wasn't the person who physically altered or withheld evidence, he could still be held accountable as the principal behind the suit. If a case could be made that he knowingly allowed the court to be misled, he could face criminal charges ranging from perjury to contempt. Even obstruction of justice, a charge that, while rare for public figures of his stature, was not impossible. It wasn't just the courtroom anymore. It was the court of public opinion. And in that arena, the fallout was already taking shape. Public trust in Harry's credibility began to slide. Charitable partnerships were quietly reevaluated. Upcoming appearances were canceled. Interviews that had been scheduled in connection with his memoir were postponed indefinitely. For the first time since his royal departure, the headlines weren't about his bravery or his break from tradition. They were about dishonesty, about evidence, about guilt. And as the legal clock continued ticking, one chilling question echoed across the country, through newsrooms, over social media platforms, and in legal circles. What else is Harry hiding? As the legal storm swirling around Prince Harry intensified, a new question began to surface, quietly at first, then louder, echoed across media platforms, late-night debates, and legal podcasts. Who else was involved? Specifically, how much did Meghan Markle know? It was a question that some found uncomfortable to ask. Since stepping back from royal duties, Meghan had positioned herself as Harry's unwavering partner, his equal in both the public eye and the private battles that followed. They were a team. They had sat side by side during the Oprah interview. They had shared intimate memories, accusations, and tears together, always presenting a united front. But in this legal fight, arguably the most high-stakes confrontation of Harry's post-royal life, Meghan had remained curiously absent. In the early days of the lawsuit, her name was mentioned only in passing. Court documents referred to her as the spouse of the claimant. No testimony was requested from her. No statements were issued jointly. In fact, the only mention of Meghan in the legal documents was related to the risk assessments used to support Harry's claims that the couple faced threats when traveling to the UK. At first, this absence seemed strategic. The case centered on Harry's right to receive protection as a member of the royal family, not as a husband or father. Keeping Meghan out of the courtroom, away from cameras and microphones, helped maintain the focus on legal arguments rather than tabloid fodder. But as the case spiraled into something far darker, Meghan's silence became harder to explain. It started with a leaked email, one of the 5 documents flagged by the Home Office as having been deliberately withheld during the discovery process. The email, dated 8 months before the court proceedings began, was from a senior aide in Meghan's office in California. In it, the aide referenced a draft security plan for a potential trip to the UK, noting that it had been shared with both Meghan and Harry, along with notes about how best to present the risk profile to justify the legal case. This simple mention, buried in what seemed like logistical correspondence, suggested Meghan had been at least aware of the strategy behind the lawsuit. More importantly, it suggested that she had been briefed about key talking points well before the public or the court had been. Legal analysts were quick to pounce on this detail. If Meghan had been consulted on matters that were later found to involve withheld information, would she too come under scrutiny? And if she wasn't legally liable, what did her knowledge mean for the integrity of the couple's public narrative? More questions followed. Had Meghan been part of the meeting in which legal advisors allegedly discussed whether to exclude certain files? Did she participate in any strategy calls with the US-based law firm working on the case? Was she among those who had access to the private servers where sensitive documents were stored? When asked these questions, a spokesperson for Meghan Markle issued a short statement. The Duchess of Sussex was not involved in the preparation or submission of evidence for this case. She supports her husband and has full faith in his legal team. It was a measured response, meant to draw a line, but it did little to stop the speculation. Former palace insiders, especially those familiar with the Sussex's inner circle, found the statement implausible. As one former aide stated anonymously to a leading British newspaper, there's not a single major move that Harry makes without Meghan being in the loop. She's hands-on. Always has been. The idea that this lawsuit went forward without her input is laughable. Then came the footage. A documentary-style project that had been quietly filmed during the Sussex's legal battles contained a brief scene that was never meant to be made public. In it, Harry is seen walking through his Montecito estate, holding his phone, visibly frustrated. The camera, still rolling from an earlier segment, captures Meghan asking, "Did they redact that part?" followed by Harry replying, "Yeah, that's handled. Don't worry." The clip is short. No context is given. But in the storm that followed the court's criminal referral, it exploded online. Suddenly, conspiracy theories bloomed. Analysts debated the meaning of her question. Was she talking about a legal document? A media statement? Something more damning? Despite calls for clarity, neither Harry nor Meghan commented on the video. Their media team refused to release the full footage for context, citing privacy and editorial rights. But the damage was done. Online discourse shifted dramatically. Once perceived as the wronged couple fighting a system stacked against them, Harry and Meghan were now being portrayed, fairly or unfairly, as power players who knew more than they had revealed. Within days of the leaked clip, additional details surfaced. According to a UK-based attorney who had brief access to the documents, one of the missing email chains was copied to Meghan's office email. Though she hadn't responded to the chain, her inclusion as a recipient was enough to raise eyebrows. Was she a silent observer or an active participant? Legal experts weighed in, pointing out that being copied on an email does not equate to culpability. But public sentiment is rarely so nuanced. Memes flooded social media. News outlets ran headlines like "Meghan's fingerprints found on Harry's legal nightmare" and "The Duchess who knew too much." Supporters rushed to defend her. Prominent voices in media and entertainment reminded the public that Meghan had already endured targeted harassment, racism, and institutional bullying. They argued that holding her responsible for the legal strategies of Harry's team was another chapter in the long-standing smear campaign against her. But critics weren't backing down. Several British MPs took to social platforms and interviews to voice concern. One called for an independent review of any and all correspondences connected to both Sussexes regarding this case. Another went so far as to suggest that the monarchy should formally denounce the actions of any member, past or present, who interfered with a legal proceeding. Within the Sussexes' circle, the once solid foundation began to crack. According to insiders, one of Harry's closest advisors resigned over the handling of the legal fallout. The advisor, whose name has not been released publicly, allegedly believed that withholding the documents was a strategic misstep, and that failing to inform Meghan of the implications would only escalate the damage. At the heart of the storm was the same question that refused to go away. If Meghan knew something, why didn't she come forward? Some speculated she was being advised to remain silent. Others believed she was trying to protect Harry, hoping the scandal would blow over. Still others wondered if she had grown disillusioned with the legal battle altogether. Whatever the truth, the silence between them had become deafening. The unity that once defined the couple visibly unbreakable during the Oprah interview and on red carpets was now under scrutiny. Every gesture was analyzed, every appearance dissected. A missed glance. An avoided topic. A statement delayed. And as the CPS inquiry deepened, Meghan's name appeared in more whispers, more rumors, more behind-the-scenes commentary. Not as a defendant. Not even as a witness. But as someone who had been closer to the center of the storm than anyone had previously believed. In the months to come, her role may become clearer. Or perhaps it will remain a murky footnote in a story dominated by scandal, secrecy, and legal warfare. But one thing had become certain. The line between what Harry knew and what Meghan knew had blurred. And in that space of ambiguity, trust, both public and private, began to fracture. Once the judge's ruling was made public and the criminal referral forwarded to the Crown Prosecution Service, a new phase of the story began, one no longer confined to legal argument or courtroom formality. This was now an investigation. An active, developing inquiry into what could potentially be one of the most controversial acts involving a member of the British royal family since the days of Edward VIII. Unlike the legal proceedings that had unfolded with predictable structure, the investigation by the Crown Prosecution Service introduced a level of unpredictability. This wasn't just about interpreting law anymore. It was about uncovering the truth. The CPS is not an entity known for haste or dramatics. It operates methodically, discreetly, and with significant legal muscle behind its every move. When it investigates, it does so with the full backing of government intelligence and law enforcement agencies, especially when national security or matters involving state figures are implicated. In this case, the investigation wasn't just about court documents, it involved sensitive discussions about security, the inner workings of royal protection, and the reliability of a former senior royal figure. The first sign that the investigation had truly commenced came quietly. Legal aides close to Prince Harry were contacted and asked to preserve all forms of correspondence, emails, memos, text messages, internal strategy documents, and even handwritten notes. These preservation orders, while not publicized, indicated that the CPS was not content to take Harry's legal team at their word. They wanted to see everything. Soon after, Scotland Yard's Serious Crime Directorate was brought in to assist in reviewing digital communications. This was significant. Scotland Yard's involvement meant the investigation had moved beyond a review of courtroom behavior into a possible breach of national protocol. Some of the withheld documents pertained directly to security logistics, and if those materials had been altered, hidden, or misrepresented in court, that could constitute a security risk. Inside sources confirmed that investigators requested server access logs from a U.S.-based law firm associated with Harry's team. These logs would show who accessed what documents and when critical information that could reveal whether anyone intentionally removed or blocked files prior to their submission to the UK court. The question was simple: did someone knowingly hide key evidence? The complexity of answering that, however, proved immense. The CPS began conducting quiet interviews with individuals close to the case. Some of these individuals were former staffers who had signed non-disclosure agreements but were now cooperating under legal compulsion. At least 2 former members of Harry's internal advisory team were brought in for questioning. Reports surfaced that one of them had submitted an affidavit confirming they were told to filter any documentation related to Harry's early discussions with Ravek. This word, filter, became central to the investigation. It implied discretion. It implied selection. And most dangerously, it implied intent. Legal analysts speculated that if the CPS could establish a clear intent to deceive the court or manipulate the case by withholding documents, charges could be brought under the Criminal Justice and Courts Act 2015. This act allows prosecution in cases where an individual intentionally distorts the course of justice. Penalties range from heavy fines to imprisonment, depending on the scale and scope of the obstruction. What made this case so unique, however, was its fusion of legal boundaries and royal proximity. Very rarely does the CPS find itself investigating someone with direct ties to the monarchy. Though Prince Harry had formally stepped away from his duties, he still carried the weight of his title and lineage. This created enormous political sensitivity. Every move the CPS made would be under the microscope. A misstep could be seen as either favoritism or persecution. And so, investigators proceeded with extra caution. As part of their work, they also contacted Ravek members directly. The committee, comprised of security officials, royal liaisons, and intelligence advisors, was asked to submit full transcripts and minutes of all meetings in which Harry's protection status was discussed. Several of these documents had not been part of the civil court case, as they were protected under national security guidelines. Now, they were critical evidence. From those transcripts, a troubling pattern emerged. Contrary to public assertions made by Harry's legal team that he had not been sufficiently warned about the revocation of his protection, Ravek records showed that communications were sent weeks in advance. Furthermore, the committee noted that Harry had received a full briefing via secure channels while still residing in Canada. One member of Ravek allegedly told investigators that Harry appeared disappointed but not surprised during the meeting, and that he accepted the terms while expressing frustration. This testimony stood in stark contrast to Harry's court claims that he was blindsided by the decision. In addition to internal committee documents, attention turned to Harry's private communication with his staff. Investigators examined a messaging platform reportedly used by his Montecito-based team. Though some conversations were encrypted and protected by American privacy laws, investigators were able to obtain court orders granting limited access to certain records. It was within these messages that they found discussions about framing the narrative. One particular thread between senior advisors appeared to discuss how to control the optics of the Home Office decision, with one participant writing, "If we focus on emotional impact, we may not have to lean on all the backdated reports." The implication was clear: they were not just presenting facts. They were strategizing presentation. Whether these discussions would meet the legal threshold for obstruction was still uncertain. The law requires not just selective framing, but actual omission or alteration of truth that misleads the court. Still, these internal dialogues didn't help Harry's image. Meanwhile, members of Parliament began to take notice. A handful of MPs raised questions in the Commons, calling for transparency and accountability. One MP, speaking in session, asked whether it was appropriate for someone under investigation for manipulating the judicial process to retain access to any royal privileges or state-funded initiatives, even honorary ones. Though no official response came from the monarchy, it was clear the matter had now entered the political arena. Publicly, the CPS remained silent. They issued only one statement confirming the initiation of an evidence review and declined to comment further on the details. But behind the scenes, the gears were turning fast. With evidence piling up and public interest surging, media pressure mounted for Prince Harry to speak. But he didn't. Not a press conference. Not a video statement. Not even a message through his official website. His silence became the story. Royal observers noted the irony. A man who had once criticized the institution for hiding behind palace walls was now doing the very same, avoiding cameras, issuing short legal disclaimers, and withdrawing from public view. The contrast couldn't be starker. This wasn't a man taking control of his narrative. This was a man being pursued by one. The investigation reached a new height when the CPS issued formal notices to 5 individuals, requesting sworn statements. Though the names were not released, insiders claimed at least one was a current employee of Archewell, Harry and Meghan's charitable organization. This revelation sparked speculation about whether the charity's resources had been involved in any capacity in the lawsuit. If even a portion of its infrastructure had been used to develop or transmit court-related documents, it could raise additional ethical concerns. The CPS emphasized that their review did not automatically imply guilt. But that didn't stop the headlines. In a media landscape where rumors outpaced facts, the narrative was already shaping itself. Harry was being investigated. The prince who once vowed to reform institutions was now under the microscope of one. And the outcome, whatever it might be, would define far more than a legal verdict. It would mark a turning point in the relationship between the monarchy, the media, and the man who walked away from it all. As news of the courtroom defeat spread and the criminal investigation gained momentum, the public's response was immediate, passionate, and deeply divided. Prince Harry, once the cheeky, beloved royal who had won hearts with his candor and vulnerability, was now the subject of a national reckoning. In a country long conditioned to either admire or scrutinize its monarchy, Harry's unfolding legal battle created something more complex, an emotional rupture. At the heart of this rupture was a single question: should the public feel sorry for him or hold him accountable? In the early hours following the judge's ruling, the streets outside the royal courts of justice swelled with media, onlookers, and spontaneous gatherings of both supporters and critics. Some carried signs reading "Bring Harry home safely." Others held placards that bluntly said "Pay your way." For many, the debate wasn't just about the courtroom. It was about values. What does it mean to leave the institution? To seek independence? And does that independence still come with the protections and privileges of royalty? Social media reflected this cultural divide in real time. The hashtag Justice for Harry trended globally within hours, supported by loyal fans who saw the legal system's treatment of him as an extension of the same institutional neglect he had described in multiple interviews. To them, this was yet another instance of the British establishment punishing Harry for daring to break rank. Thousands of users reposted clips of his past interviews, his military service, and his charity work with captions framing him as a target of systemic suppression. But there was another side of the internet equally fired up. The hashtag No More Royal Exceptions also gained traction. This camp was less sympathetic. Their tone was critical, often scathing. Many British citizens took offense at the idea of a taxpayer-funded system being manipulated by someone who had deliberately removed himself from the working royal roster. They saw Harry's lawsuit not as a plea for safety, but as an entitled attempt to rewrite the rules. Some commentators pointed out that ordinary UK citizens with legitimate threats against their lives could not access private police protection, regardless of wealth or fame. One social media post that went viral read, "My cousin got a restraining order and still walks to work alone. Why should a millionaire in California get Met Police just because he's upset with Granny?" The divide wasn't just virtual. On the ground, cafes, pubs, and households were buzzing with opinion. In London, a small protest emerged outside the Home Office building. A group of veterans gathered, holding signs that read "Protect Our Soldier Prince," highlighting Harry's military service and the belief that the state had a moral obligation to protect one of its decorated veterans. Across town, another group formed, voicing opposition to special treatment, chanting "One law for all" and showing disdain for any notion of inherited privilege in modern justice. Newspapers capitalized on the moment, dedicating their front pages and op-eds to the fallout. The Guardian ran a thoughtful analysis under the headline "Prince or Petitioner, when the Crown meets the court." The Daily Mail, known for its critical stance on Harry and Meghan, took a more combative approach, splashing their cover with the words "Harry humiliated. Court exposes legal stunt gone wrong." Television coverage was relentless. Every hour brought a new guest: constitutional scholars, royal biographers, legal analysts, even psychologists. Morning talk shows invited families to weigh in, treating it like a national referendum on Harry's character. Some hosts expressed open sympathy, recalling Harry's past trauma and the pressure of growing up in the royal spotlight. Others were less forgiving, questioning why someone with such vast resources and media access had chosen to fight a case that many felt was rooted in ego. Polls were quickly conducted to gauge national sentiment. One conducted by YouGov within 48 hours of the ruling revealed a sharp generational divide. Among citizens over the age of 55, 72% believed Harry should accept the court's decision and cease further legal action. Among younger adults aged 18 to 25, support was split almost evenly, with a slight majority expressing concern over how he had been treated by both the government and the royal institution. International media picked up on the drama as well. American outlets, especially those sympathetic to Harry and Meghan, took a more cautious approach, focusing on the implications of institutional retaliation. But even there, cracks began to appear. Prominent television personalities questioned the optics of withholding documents. Legal pundits on major news networks discussed the dangers of conflating celebrity status with legal immunity. Meanwhile, celebrities and public figures also began to choose sides. Some tweeted in solidarity. A-list actors, authors, and political commentators voiced support, drawing comparisons to other whistleblowers and dissidents who had faced retribution for telling uncomfortable truths. Others remained silent, possibly wary of being associated with a story that was now becoming legally murky. And there were those who changed their tone altogether. An actress who had once lauded the couple's decision to leave the royal family deleted several older posts supporting them, issuing a new message that read, "Standing up for yourself is one thing. Bending justice is another. Do better." The emotional component of the public reaction couldn't be ignored. For many, this wasn't just about legality or privilege. It was about disappointment. Harry had been the relatable royal. The one who smiled in the rain, who hugged children without hesitation, who laughed at himself. He had represented the idea that it was possible to be both royal and real. Watching him become entangled in a case now riddled with potential dishonesty felt, to some, like watching a hero fall from grace. But others felt a more complicated mix of emotions: sympathy, frustration, even guilt. Some admitted they had supported Harry's departure from the monarchy because they believed in his need for freedom. They admired his candor and vulnerability. But now, watching the investigation unfold, they were no longer sure where the line between victim and manipulator began or ended. One powerful editorial captured this uncertainty. Published in the Times, it read, "Perhaps we expected too much. We wanted him to be the prince who broke the system, the one who redefined duty. But maybe, just maybe, he's simply human, fallible, flawed, and frightened." Charities associated with the Sussexes also found themselves caught in the crossfire. The Archewell Foundation received dozens of inquiries from donors and stakeholders asking for reassurance that funds had not been used in any way connected to the legal battle. While no such misuse was confirmed, the concern alone was enough to shake confidence. Some organizations paused public affiliations. A youth mental health charity that had partnered with the Sussexes for an awareness campaign postponed the release of its promotional content, citing the need to focus on internal priorities. The implication was clear. The association was now at risk. Meanwhile, journalists uncovered internal messages from within the Archewell team that suggested frustration with how the situation was unfolding. One staff member, who had since resigned, was quoted anonymously as saying, "We weren't hired to clean up a legal mess. This isn't what we signed up for." As public opinion splintered, the emotional toll on Harry seemed to become more visible. Photographs emerged of him walking alone near the Montecito coastline, head down, hands in his pockets. He wasn't smiling. He wasn't waving. He looked, as one headline described, like a man at war with himself. For supporters, these images stirred renewed empathy. For critics, they felt like calculated optics. Either way, the impact was undeniable. This was no longer just a court case. This was a cultural moment. A moment that forced a country, and much of the world, to ask itself whether the line between royalty and citizen should ever have been so blurred. Whether truth and transparency could exist in a world built on protocol and legacy. And whether one man, no matter how well-intentioned, could fight the system without becoming a casualty of it. When the judge referred Prince Harry's case to the Crown Prosecution Service for further investigation, it wasn't just a procedural footnote, it was a legal alarm bell. For many watching the case unfold, it signaled a turning point. A royal, even one who had distanced himself from the crown, was now potentially facing criminal consequences for actions taken in a civil court proceeding. The weight of that implication began to settle not just on Harry, but on the entire legal and political establishment. At its core, the CPS's involvement was about one thing: accountability. The question was no longer whether Harry should receive police protection, but whether he or members of his team had knowingly misled the court by withholding, redacting, or otherwise manipulating evidence critical to the case. If found guilty, the repercussions could extend far beyond fines or public rebuke. They could land him in prison. The legal terminology used in the judge's statement was deliberate. He referred to concerns of reckless disregard for evidentiary integrity and credible indications of deliberate omissions. These phrases suggested more than simple clerical error. They hinted at intent, or at the very least, gross negligence. To understand the seriousness of the potential charges, legal analysts quickly turned to the Criminal Justice and Courts Act of 2015, under which several related offenses could be prosecuted. Obstruction of justice, perverting the course of justice, and contempt of court were all possibilities under consideration. These are not trivial infractions. They are felonies, and conviction can carry penalties ranging from substantial fines to multiple years of imprisonment. Let's break it down. Obstruction of justice is broadly defined as any act that corruptly attempts to influence, obstruct, or impede the administration of law. This could include hiding documents, lying under oath, encouraging others to withhold information, or interfering with an investigation. If prosecutors can demonstrate that Harry was aware of missing or manipulated documents and allowed them to be submitted anyway, they could pursue charges under this statute. Perverting the course of justice is a more serious and specific offense. It usually involves actions taken with clear intent to derail a judicial proceeding. This could be as overt as destroying evidence or as subtle as instructing legal counsel to avoid including damaging material. What makes this charge particularly damning is its requirement for proof of intent. It's not enough to show a mistake or oversight. The prosecution would need to show that Harry or his advisors actively made decisions to mislead the court. Contempt of court, though often used in less severe circumstances, could also be applied if it's found that Harry's legal team disobeyed court orders or behaved in a way that undermined the authority or integrity of the judicial process. Even if prosecutors choose not to pursue the more severe charges, a contempt charge could still carry serious consequences, financial penalties, formal reprimand, or even brief incarceration. For a private citizen, any one of these outcomes would be a nightmare. For a public figure of Harry's profile, the consequences could be existential. Not only would he face potential criminal penalties, but his entire public persona, carefully shaped around honesty, vulnerability, and moral conviction, would be called into question. His standing as a global advocate for mental health, veterans' rights, and institutional reform would be compromised. And his ongoing legal entanglements in both the UK and the US would become even more precarious. The unique position Harry holds makes this case more complicated than most. He is not a working royal. He is not a citizen living permanently in the UK. And yet, he retains a level of fame and influence that transcends both borders and systems. Prosecuting such a figure comes with inherent risk. If the CPS goes forward with charges, they will be accused by some of carrying out a political vendetta. If they do not, others will claim that the legal system is biased in favor of the elite. This tension has left the CPS in a delicate position. They must not only weigh the legal merits of the case, but also its public and political ramifications. For that reason, the review process has been unusually thorough. Experts in criminal procedure, digital forensics, and even constitutional law have been brought in to examine the available evidence. Among the most closely examined items are the redacted documents submitted by Harry's legal team. According to multiple sources familiar with the case, the CPS is investigating whether those redactions were made in good faith, meant to protect sensitive information, or whether they were strategic omissions designed to hide inconvenient truths. If the latter can be proven, it could form the foundation of a charge for perverting the course of justice. Digital communication records are also under review. Text messages, emails, and internal memos between legal staff, advisors, and outside consultants are being scrutinized for signs of collusion or coordination. The discovery of the now infamous voice memo in which one staffer is heard suggesting that including certain documents would weaken our position has already set off alarm bells. Prosecutors want to know whether that sentiment was isolated or indicative of a larger strategy. The involvement of American legal counsel adds another layer of complexity. Because much of the communication originated in the United States and involved American advisors, questions about jurisdiction and cooperation between the UK and US authorities have emerged. While the UK cannot compel testimony or document production from individuals residing in the US without a mutual legal assistance treaty, informal cooperation is often used in high-profile cases like this one. Even if charges are never formally filed, the mere possibility of criminal proceedings has triggered significant fallout. Harry's existing legal cases, including his ongoing lawsuits against British tabloids and his involvement in privacy-related advocacy, are now under heightened scrutiny. If his credibility as a truthful and transparent litigant is damaged, those cases could be weakened. Defendants in unrelated lawsuits may point to this case as evidence of a pattern of behavior. Furthermore, Harry's personal and professional life has begun to shift in response to the legal uncertainty. Some charitable boards are quietly discussing whether his involvement may be a liability. One global foundation reportedly postponed a speaking engagement he had been scheduled to headline, citing concerns about the current media climate. Public relations advisors have reportedly urged him to remain silent, avoid appearances, and allow the process to play out legally rather than emotionally. But silence can only go so far. The longer Harry avoids speaking directly about the criminal inquiry, the more speculation fills the void. Is he preparing a defense? Will he release a new public statement? Could he return to the UK to cooperate with investigators? Or will his physical absence be interpreted as evasion? Then there is the question of what a prosecution, even an unsuccessful one, would mean for the royal family as a whole. Even though Harry is no longer a working royal, his association with the monarchy remains central to his identity. Any legal action against him would inevitably draw the crown into the conversation. Questions would resurface about institutional accountability, favoritism, and the responsibilities of the state toward its former representatives. It could even revive debates about royal immunity, the future of the monarchy, and the public's trust in its historic institutions. Privately, royal sources have expressed frustration, not necessarily because Harry is under scrutiny, but because the spotlight has once again been turned toward the palace. While the family has worked hard to project unity and stability, this case threatens to unravel those efforts. Every headline mentioning the investigation links back to Buckingham Palace. Every photograph of Harry in court is a reminder of the institution he once represented. Legal commentators remain divided on how the CPS will proceed. Some believe the evidence is damning and that the public interest in accountability demands prosecution. Others argue that the risks, political, cultural, and constitutional, are too great and that a negotiated resolution, such as a formal reprimand or financial penalty, may be more appropriate. What is clear, however, is that the legal fallout will linger. No matter the outcome, this case has reshaped how Prince Harry is perceived, not just in Britain, but around the world. The carefully constructed narrative of the brave prince speaking truth to power has been complicated by allegations of dishonesty. The man who once challenged the system may now be seen as someone who tried to bend it. And as the investigation moves forward, one fact remains impossible to ignore. There is no royal exemption from the rule of law. As the legal and public scrutiny surrounding Prince Harry reached a boiling point, one voice, or rather, a chorus of voices, remained conspicuously silent. The British royal family, historically practiced in navigating crisis through stoic silence and polished restraint, had not issued a single statement about Harry's courtroom defeat or the criminal investigation that now hovered over his every move. Not a word from Buckingham Palace. No expressions of support or concern from Clarence House. Not even a simple acknowledgement of the controversy from Kensington Palace. To many observers, the silence spoke volumes. Traditionally, the royal family's approach to scandal has been to retreat behind closed doors, allowing the press and public discourse to run their course. Public acknowledgement often came only when absolutely necessary, and even then, carefully worded to avoid blame or emotion. But this case was different. This wasn't a tabloid rumor or a personal dispute. It was a legal scandal involving allegations of misconduct that could have ramifications far beyond one man's reputation. Royal watchers and former courtiers began to speculate. Was the silence just adherence to tradition? Or was it a strategic maneuver? Sources close to palace operations suggested the latter. According to one senior figure who spoke off the record, the institution had been preparing for the possibility of this exact moment. When Harry first filed his lawsuit challenging the Home Office over his lack of protection, there was concern behind palace gates. Not necessarily because of the content of the case, but because of the precedent it could set. A royal, even one who had stepped away, dragging the government into court? That wasn't just legally dangerous, it was constitutionally awkward. The decision, early on, was to avoid public comment, allow the legal process to unfold. But when the court ruled not just against Harry, but also referred elements of the case for potential criminal prosecution, internal discussions reportedly escalated. Advisors debated whether to issue a short statement reaffirming the family's confidence in the judicial process. Others cautioned against any involvement, fearing that any expression, sympathetic or not, could be interpreted as taking sides. What resulted was calculated distance. King Charles, known for his meticulous attention to optics, reportedly instructed aides to avoid even the appearance of coordination with Harry's legal strategy. Any hint that the palace had inside knowledge or involvement would invite public suspicion. As one former press secretary put it, the safest move was no move at all. Behind the scenes, however, feelings were far from neutral. Sources familiar with palace dynamics revealed that Prince William was furious. According to these insiders, William had viewed Harry's lawsuit as reckless from the beginning. He believed it undermined the quiet dignity the institution had always relied upon to maintain its authority. When the case took a turn toward potential criminal charges, his frustration turned into something closer to contempt. There were reports that William refused to take calls from Harry during the height of the courtroom proceedings. The relationship, already strained from years of public tension and private disagreements, now appeared to be severed entirely. One courtier described it simply, "The line has gone dead." For Queen Camilla, the scandal reportedly reopened old wounds. She had faced her own media storm decades earlier, and while she had emerged with public acceptance, it had taken years of silence and strategic patience. Watching Harry's very public unraveling, Camilla is said to have expressed concern, not for the legal consequences he might face, but for the institution's image. In her view, the longer the scandal dragged on, the more it distracted from the monarchy's ongoing attempts to modernize and stabilize under King Charles's reign. As for Prince Edward and Princess Anne, their silence was expected. They have long preferred to operate away from the limelight, and insiders suggest their views align more with tradition. While neither publicly addressed the issue, aides indicated they supported the palace's decision to remain uninvolved. One of the more intriguing questions, however, was whether the palace had privately offered Harry any legal or emotional support. According to sources close to the Sussexes, no such overtures were made. In fact, communication from palace officials reportedly ceased altogether once the criminal referral was made public. It was as if a cord had been cut, formally, cleanly, and completely. The estrangement was evident in more subtle ways, too. When King Charles attended a charity gala shortly after the judge's ruling, reporters shouted questions as he exited his vehicle. "Do you support your son? Is Harry still welcome at Buckingham Palace?" The king smiled politely, adjusted his cufflinks, and walked inside. He made no comment. That same week, Princess Kate was seen attending a community event in Leeds. She was warm, poised, and seemingly unbothered. When asked by a member of the public whether the royal family was okay, she responded with a practiced smile and a soft yes. It was the closest anyone in the family came to addressing the scandal. Still, the royal family's silence didn't shield them from critique. Several commentators accused the institution of moral cowardice, arguing that if Harry was truly family, he deserved at least a modicum of public support. Others disagreed, insisting that the silence was the right call. "Any comment," they said, would only fuel speculation and feed media chaos. Meanwhile, international media took note of the palace's detachment. American outlets speculated whether this marked the final break between Harry and his royal relatives. Commentators suggested that the royal family had drawn a line in the sand, choosing preservation of the crown over reconciliation with a rebellious prince. The lack of communication between Harry and his family became more obvious as the investigation deepened. There were no visits, no video calls, no intermediaries shuttling messages. As one insider told the press, he is on his own now. And perhaps that was the most damning revelation of all. For a man who had once been second in line to the throne, who had stood on the Buckingham Palace balcony beside his brother and father, the silence from the family wasn't just a strategic decision. It was a verdict in itself. He had chosen to leave, and now, as he stood under the weight of a legal scandal, he would face the consequences alone. What remains unclear is how permanent this silence will be. If charges are filed, will the palace maintain its detachment? If Harry is cleared, will bridges be rebuilt? Or has the damage, after years of public spats and private grievances, finally become irreversible? For now, the royal family waits. Silent. Strategic. Watching from behind palace walls, as one of their own navigates the storm of public opinion and legal peril, with no guarantee of rescue from the institution he once called home. Long before courtrooms, security disputes, and legal investigations, Prince Harry was defined by a singular, tragic identity. He was Diana's son. The boy who walked behind his mother's coffin, head bowed, cheeks flushed with silent grief, forever etched into the collective memory of a nation. That image had come to symbolize innocence lost, a child pulled into the machinery of monarchy and media before he had the tools to understand either. For many, that association has never faded. Diana's legacy hovered over Harry's public life like a shadow, both protective and defining. Her name was invoked during his most vulnerable interviews. Her story echoed in his choices to walk away from the institution, and her memory framed his quest for privacy and protection. She had died, he often reminded the world, because of a reckless chase for a photo. He would not let history repeat itself. But as Harry's legal drama unfolded and the accusation of withholding evidence took center stage, a painful question emerged. Was this truly a continuation of Diana's legacy, or a distortion of it? Supporters were quick to defend the connection. They argued that Harry's relentless pursuit of protection was born not of entitlement, but of trauma. That his legal actions, even if flawed, stemmed from a desire to avoid his mother's fate. To them, Diana's legacy wasn't being questioned. It was being honored, in the most personal and painful way possible. Yet others weren't so sure. Critics pointed out that Diana, while deeply critical of the institution, had never sought to undermine its foundational principles. She had fought battles, yes. She had exposed hypocrisy and dared to speak out. But she had also been careful, strategic. Even when divorced and stripped of her HRH title, Diana remained bound by a sense of royal decorum. She never filed lawsuits against the crown. She never attacked the system through the courts. So was Harry honoring her memory or manipulating it? This debate reached a fever pitch when archival footage of Diana resurfaced across major platforms. One particularly poignant clip showed her speaking about accountability during her 1995 Panorama interview. She said, "The monarchy has to be trusted. It has to be seen as moral, as decent, and when mistakes are made, they must be owned." That line was replayed again and again, now viewed in a new light. If Diana had insisted on transparency and moral conduct, would she have supported her son's decision to withhold or redact key evidence in a court of law? Would she have encouraged secrecy, strategic omission, or would she have pulled him back, reminded him that doing the right thing must always outweigh the desire to win? Some royal commentators didn't hesitate to voice their opinions. One well-known biographer who had interviewed Diana multiple times stated that she would have been heartbroken to see this. Not because Harry is in trouble, but because he may have crossed a line she never would have. But the debate didn't stop at commentators. It spilled into the public square. Online communities once united in admiration for Diana began to fracture. Hashtags praising her legacy were now mixed with questions and doubts. People began to post side-by-side comparisons of Diana's interviews and Harry's court appearances, searching for consistency or contradiction. A social media post that gained significant traction read, "She walked through fire, but never lied. Can Harry say the same?" Others pointed to Meghan's involvement, or lack thereof, and questioned whether Diana's memory was being used selectively. invoked when convenient, but discarded when uncomfortable. A writer from a prominent British magazine penned a controversial piece titled The Ghost of Diana, which argued that both Harry and Meghan had leveraged her story to build their own, but had failed to live up to the principles she embodied. Still, it would be unfair to ignore the raw emotional foundation beneath Harry's actions. He had watched his mother's life deteriorate under public pressure. He had experienced the pain of losing her not to illness or war, but to the consequences of being too exposed. It was trauma that shaped his worldview, trauma that justified, at least to him, his relentless pursuit of protection. In court documents and interviews, Harry repeatedly referenced Diana as the root of his fear. He cited specific threats against Meghan and their children, tying them back to the same toxic media culture that once hounded his mother. He wasn't just fighting for himself, he claimed. He was fighting to break the cycle. But critics still asked, can trauma excuse deception? That question lingered as the legal inquiry deepened. The court had not challenged the legitimacy of Harry's fear. It had not dismissed the threats he claimed to face. What it had questioned was the manner in which he pursued justice, the methods, the omissions, the choices. It was here that the legacy of Diana seemed to crack, not because her love for her sons was ever in doubt, but because the path Harry had taken to preserve that love's memory now risked contradicting the values she had lived by. Integrity, vulnerability, moral clarity, even in the face of personal pain. Another dimension emerged as royal insiders began speaking anonymously to the press. One close friend of Diana's, now in her 70s, reportedly told a journalist she never would have wanted this. She wanted Harry to live freely, not to carry her trauma like a sword. Meanwhile, outside Kensington Palace, visitors continued to leave flowers near the gate dedicated to Diana's memory. But tucked between the roses and handwritten letters were newer notes, some addressed to Harry, some to Diana herself. One note read, "We love you both, but please don't use her to justify mistakes." It was a sentiment felt by many. The tragedy of Diana had always been about the human cost of institutional indifference. Her vulnerability, her heartbreak, her courage to speak, it moved millions. Her legacy became a symbol of truth-cutting through tradition. For Harry, invoking her name was never manipulative in intention. It was deeply personal, perhaps too personal. But now, with a legal case collapsing under allegations of dishonesty, even that sacred legacy was being questioned. Not denied, not diminished, but reevaluated. In this moment of crisis, Harry no longer stood as the boy who lost his mother. He stood as a man facing the consequences of his decisions. And for many, the question remained painfully unresolved. Was Diana's legacy being carried forward? Or was it being buried under the weight of a son's misguided crusade?